There are many types of wage garnishment laws, but it should only be considered a collection tool of last resort. In most states, the garnishment process can only be initiated by a court order, and only if a judgment for monies owed has been entered. According to David Cherner, Legal and Legislative Director of State Government Affairs for ACA International, the Association of Credit and Collection Professionals, garnishment comes in different forms. The following are 3 types of wage garnishment. Number 1, IRS Tax Levies. The Payday Resources, in its brief number 7 in May 2009, reported that tax levies have sharply increased from over 500,000 in 2000 to 3.7 million in 2007. A taxpayer incurs tax levies when he or she fails to pay federal or local income taxes on time. Citing Payday Resources, the IRS has 10 years to collect a liability from the date it puts the liability on its books. When the 10 years is up, the tax is cleared from the IRS's books and can no longer be collected. As a way to resolve debts, many individuals with tax problems work with the IRS via offers in compromise, or OICs. As reported by Payday Resources, the IRS accepted 11,618 offers in compromise in 2007. Tax levy is the IRS's last resort to collect payment from a delinquent taxpayer. A company's receipt of a tax levy could indicate that the government has exhausted all other collection schemes with the employee and that all these actions did not succeed. As a final recourse, therefore, debt is collected via payroll deduction. It should be noted that tax levies include the tax due plus the corresponding interest and penalties. Tax levies takes precedence over all other garnishment types, except for child support that has taken effect before the tax levy has been imposed. The second type is child support orders. Child support orders are court or administratively ordered deductions of a specific amount from a parent's income for the purpose of child support. Generally, garnishment is limited to a maximum of 25% deduction from the debtor's disposable income. However, child support orders can demand deductions of up to 50% or more. It is a mandate for all employers throughout the U.S., including U.S. territories, to honor an income withholding order or notice for child support from any state. A standardized withholding form called Income Withholding for Support, or OMB 0970-0154, is required for all states to use. A child support income withholding order or notice is given the highest priority among all other garnishments, with the exception of an IRS levy that was entered prior to the establishment of the child support order. Number 3, third-party collections. Another common source of employee wage garnishment comes from collection agencies done by third parties. These can be individuals, businesses, or debt collection agencies, which are the most common, that have bought debt from another source. This type of garnishment is typically court-ordered. Federal law limits the amount of employee wages that are subject to third-party garnishments. The lesser of 25% of the employee's disposable earnings, which are earnings remaining after all legally required deductions have been made, both state and federal taxes, Social Security, and Medicare contributions, or the amount which disposable earnings exceed 30 times the current minimum hourly wage of $6.55 through July 24, 2009, to increase to $7.25 after that day. A base wage floor initially determined by the Fair Labor Standards Act and later modified through subsequent federal legislation. For more information on wage garnishment and how it affects you, visit www.garnishwage.com. You will be able to access more resources and learn what options will work best for you.